Hello everyone. So today we are going to discuss Article 31C. Why 31C? Because it was in news last year as being a long pending constitutional issue which got resolved by the judiciary, and there was one more political angle to this article which said when Sam Pitroda, the head of the Overseas Congress, has said that if we will come into the power, we will introduce the inheritance tax as it was usually existing in the USA in order to grab the private properties for the furtherance of the objective of Article 39B and C. So let's see what is this whole issue all about and what is the real status after this judgment. Article 31C will cover its various aspects. We will see a brief history of it, how it evolved, then what is the current issue, why it was taken up by the judiciary, then what is the doctrine of revival which was applied by the judiciary for the continuity of the constitution, and then the judgment and its implications. Let's start step by step. So when we will see that Article 31C was introduced by 25th Amendment 1971. It was introduced in 1971 by the government and with the purpose of achieving the objective of 39B and C. If we will see, it is generally an exception to the general rule. If we will see that in our constitution there is a fine balance between individual rights and socialistic perspective. Therefore, fundamental rights have given precedence over DPSP by our framers of the constitution. Here individual liberty has a precedent, has a weightage over the DPSP. Okay, but in few exceptions this situation can be reversed when, in order to meet the socialistic goals, welfare of the society, in few exceptions DPSP can be given precedence over the fundamental rights. What 39B and C talks about? They say that if there is some material resource for the community, material resource for the community which can be taken by the government in order to meet the good of the people, to subserve the common good, to subserve the society and citizen of the India. So in that case we can give precedence to DPSP over the fundamental rights, and 39C says that it tries to curb the concentration of the wealth in individual's hand. Concentration of wealth in order to ensure the distributive justice for the social equality, economic equality. So these exceptions has been made because India is considered to be a welfaristic state, a socialistic state. So 25th Amendment says that any law which have been passed in order to meet the objective of Article 39B and C, means material resource of the community and concentration of wealth, in order to curb this, that law cannot be challenged on the ground of contravening Article 14 and 19. It simply says that अगर कोई कानून any law अगर वो 39B और C के ऑब्जेक्टिव को फुलफिल करने के लिए पास किया जाता है तो इस आधार पे उसको हम चैलेंज नहीं कर सकते कि वो अनुच्छेद 14 और 19 का उल्लंघन करता है. It means it gives immunity from the clutches of Article 14 and 19. So here it is a kind of exception to the fundamental rights. Second part, which is the most controversial part of this amendment, which says, this was the first part. Second part says that any law which has been passed in order to meet the goals of 39 and B and C cannot be challenged on the ground that it has not given effect to that purpose. Means it denies any nexus. I'll explain in the simple words that, for example, if I have taken, government has taken property of some individual in order to open a college or a university for the common good, and with the manifested goal of achieving the objective of 39B and C. So here it will be immune from Article 14 and 19 because to meet the common good, to serve the common good. Okay. Now second part says that it should not be challenged in order on the ground of not meeting the said objective. Means मैंने प्रॉपर्टी लिया कॉलेज के लिए, गवर्नमेंट ने प्रॉपर्टी कॉलेज के लिए लिया आर्टिकल 14 एंड 19 के कॉन्ट्रावेंशन में. ओके, बट ये सेकंड पार्ट कहता है कि इस आधार पे चैलेंज कोर्ट में नहीं किया जा सकता कि जो ऑब्जेक्टिव बताया गया था कि मतलब कॉलेज वहां पे ओपन हुआ कि नहीं, प्रॉपर्टी तो ले ली बट अगर कॉलेज वहां ओपन नहीं होता तो भी इट कैन नॉट बी चैलेंज. सो इट इज कंप्लीटली, इट वाज, दिस पार्ट इज टेकिंग कंप्लीटली away the judicial review power of the judiciary. So on this ground, this second part was challenged in the Keshwanand Bharti case. Keshwanand case in 1973. We all know about this case because the concept of basis structure was evolved by the Keshwanand case only. So in that case it was held that this is in contravention with the scheme of thing because it is taking away the power of judicial review. So second part was struck down by the court. So now at that time only this part was remained because second part was struck down. Now again the controversy began when in 1976 White 42nd Amendment Amendment 1976, government has substituted these words 39B and C. Article 39B and C was substituted by giving effect to all the DPSP. Means previously it was limited to the objective of Article 39B and C, but after the 42nd Amendment 1976 it was meant for all the DPSP. So in simple words it can be said that किसी भी DPSP के ऑब्जेक्टिव को मीट करने के लिए अगर कोई लॉ पास होता है तो वो इस आधार पे उसको चैलेंज नहीं कर सकते कि वो सेट ऑब्जेक्टिव कि वो एक आर्टिकल 14 और 19 का उल्लंघन करता है. सो इट कैन नॉट बी चैलेंज ऑन द ग्राउंड ऑफ कॉन्ट्रावीनिंग द प्रोविजंस ऑफ आर्टिकल 14 एंड 19. इट गिव्स इम्यूनिटी. हाउएवर in 1977 again this issue was taken up in the case of Ranganath Reddy case. in which majority decision held that private property cannot be taken for the common good. This principle cannot be applied. But the minor judgment that was of Justice Krishna Iyer, a well renowned and very socialistic perspective judge, he said that any individual property can be taken for the common good of the people, because India being a welfaristic state, if it thinks that it is for the larger interest, for the larger good, it should and it can take away. And the whole confusions and this the whole pending issue begins here, because in the following judgments, like in Vaman Rao case, and then in Sanjeev Kok case, and finally in Mafat Lal case also with the 9 judges bench, they have concurred with the minor opinion of Justice Krishna Reddy in the Mafat Lal case also. So, the real issue was that what is the real status of the Article 31C. There was one more interesting step we can say in this whole history. We see in the Minerva Mill case. In the Minerva Mills case, in 1980, 5 judges bench was formed to clarify the status of Article 31C. And here in the Minerva Mills case, it was held that it cannot be given effect to all the DPSP. That substitution for the complete DPSP was challenged. That as far as Article 39 BNC was concerned, it was accepted by the Keshwan and Bharti's case. But in Minerva Mills, that substitution was got struck down. So, in such scenario, after the Mafat Lal case and Minerva Mills case, we can see the whole situation was quite conflicting. What is the real status of the Article 31C? However, so what is the current issue? Why it's again taken up by the judiciary? Here, an act of MADHA was challenged, Maharashtra Urban Area Development Authority 1977 Act, in which some individual properties has been taken for the restoration purpose and some other purposes for the set purpose of furtherance of the article objective of the Article 39 B and C. So, it was challenged in the Supreme Court. Here Supreme Court was having 2 opinions, whether all the properties or some of the properties can be taken in order to meet out the objective of 39 B and C, or can any property or no property can be taken. Can individual property should be considered as material resource for the community or not? So, the real challenge was what is the material resource of the community, and whether private property can be considered as the material resource of the community or not. So, in this case, CJI has observed that Justice Iyer was wrong in his opinion of considering all the private property as a material resource for the community, because that would be amount to adhering a certain kind of ideology, a Marxist ideology of taking away all the individual's liberty and property in order to meet the socialistic goal. But in Indian constitutional scheme of things, we can see that there is a fine balance, a harmonious balance between the individual interest and the socialistic purpose perspective. So, in order to make a balance, we have to weigh both the side. So, CJI had said, Justice Chandrachud had observed that all the individual property cannot be said as a material resource of the community. It cannot be said. But it's contrary or not true. Some properties can be taken if they fulfill certain criteria. Judiciary has evolved certain criteria. If they fulfill such kind of criteria, then it can be, but not all the properties suo motu or automatically cannot be considered as a community property. Again, it means to say that there should be some check and balance, because economic justice and social justice should be weighed in order to make a balance between the individual liberty and economic democracy. So here it was certain points have been observed to check whether the property is community good materials or not, that whether it is, can be considered a material resource, एक भौतिक संसाधन का इसको हम समाज के लिए एक भौतिक संसाधन समुदाय के लिए मान सकते हैं कि नहीं, इसको लेके हम कुछ क्राइटेरिया चेक करने. एंड सो व्हाट इज द इम्प्लीकेशन ऑफ दिस जजमेंट? Actually, it has revived, it has accepted the doctrine of revival. This doctrine was evoked, doctrine of revival, because after the Minerva Mill judgment, when that substitution of all the DPSP wide, the 42nd amendment has been struck down, so it was very confusing what is the real status of Article 31 and 31C, because if substitution, that modified provision was struck down, so whether the previous unmodified version is in existence or not. Similarly, in the following cases, when the minor opinion of Justice Krishna Iyer was followed by the various benches, so what is the real status? So doctrine of revival has said, it means that if any modified amendments or provision was struck down, it means that previous provision which was in existence will remain in existence without any explicit judgment on that. There is no need to clarify that issue. And why it was? Because for the continuity of constitution, it is needed. Similarly, constitution cannot be remain in vacuum. So post Keshwanand status was accepted, that second part is inoperative. Article 39B and C is in existence, and any act that is passed with the objective of meeting out the 39B and C objective, it is valid. And finally, all properties cannot be considered, all individual property cannot be considered as a material resource for the community. What is the implication of this judgment? If we'll see that it helps in continuity and stability of constitution, because in absence of doctrine of revival, the whole continuity of this constitutional process would have been got disturbed. So here it helped in continuity and stability. Moreover, it sets out a precedent for the following cases, which will become in the following days for the future issues. So it's will definitely it will help in setting out the precedent. Then it also shows the flexible approach of our Indian judiciary, a very practical and applied and pragmatic one to resolve any long pending issue. Definitely it is commendable. Then it also gives a roadmap for the legislative process, how and what kind of law they can pass, and balance between the legislative process and the socialistic welfare policies to make a fine balance between the both. So we can definitely say that our judiciary has evolved a very harmonious, a very constructive balance between two prime objective of our constitution, that is fundamental rights and DPSP, and their balance is very necessary in order to meet out the objective of the our constitution. So मैं उम्मीद करता हूँ आपको आज का ये विषय, ये चर्चा अच्छी लगी होगी, आपके लिए एक महत्वपूर्ण बिंदु रहा होगा और आपको इससे हेल्प मिलेगी आगे इस संबंध में, इस विषय को समझने में. आई होप एंड आई प्रॉमिस दैट विल अगेन कम अप with such kind of important issues which were in news, and you can take help of it. Thank you.